Welcome back to the Friday Five for November 4th, 2022. My name is Andrew Ayers. I'm an estate planning and business law attorney. I've got offices in Edina, Minnesota and New York City. And today we're going to look at 5 questions that came up in this past week. Apologies for last week. I didn't have a chance to make a Friday Five as I was out of the office for the week at a conference. I was hopeful of shooting one at the hotel, but unfortunately the lighting was terrible and their internet was ridiculously slow, so we didn't get around to doing a Friday Five. But back for this week, we got question number 1. What happens when we have another child after we sign our will? So clients came to me and were working on their will, and they just had a child, and chances are in the future they intend to have more children. So their question is, as we're putting together this will, what do we do when we have another child? And the question is really going to focus on how many changes do we need to make to the will. If we have a straightforward will that just says everything I have goes to my children, then we don't really have to make a lot of changes other than what's called a codicil, which is a fancy legal term for a change to a will, and add in that new child to the will. However, if you didn't have any children before, or we want to make some major changes to your will, you may want to look at whether or not it makes sense to do a new will. If you didn't have a child before and you did a will, you probably don't have provisions in there for guardianship or trustee for a child who's under the age of 18. So in that case, you probably want to do more than just a codicil. You want to really revamp your will and also consider whether or not you want to add a trust. We can have a trust in the will, called a testamentary trust, or we can create a standalone trust, usually a revocable living trust, to make sure that we're preparing for that child and protecting their legacy. Question number 2, similar vein, was do newlyweds need a will? So I got a call from a client from a few years ago, recently got married, and she wanted to know whether she and her husband should do a will or not. Now, obviously when you call an attorney who does estate planning and you ask us, do you need a will? Almost all the time we're going to tell you, you probably need a will. It's a good idea. Now, in their situation, they're in a state that has what's called the elective share, which means that even if you do a will and you try to cut out your spouse, they can still elect for a portion of the estate. And the reality is that if you're a married couple, even if you're just newly married and most of your accounts are joint, you may not necessarily need a will. There may not be any separate assets of yours, but it's always a good idea to have a will, to have an estate plan put together for you so we make sure we've got everything in place. Now, for the newlyweds, the will may not be as important, but the healthcare documents can be really important. They're a young couple. If something happens to one of them, we want to make sure that the spouse is there to make the proper healthcare decisions for them. Question number 3 this week, how do I put my house into a trust? So I've had this over the years where clients have created a trust and they want to put their house into the trust. Frankly, oftentimes it's they had a previous attorney prepare the trust, but the house never got moved over into the trust. The reason is they thought when they created the trust, they signed the long document, that was it, that's all they needed, the house is in the trust. But there's a second step that you need to go through beyond just signing the trust, and that is filing an updated deed with your local property registrar. The deed will say it's now owned by the trust, so you're transferring it from you or you and your spouse into the trust. And that deed needs to be done, and your insurance needs to be updated as well. So if you have home insurance, if you have an umbrella policy on your house, the insurance companies need to know that that house is now going to be owned by the trust. So these are little pebbles that can come up when you create an estate plan with a trust that you want to make sure you don't trip over, because they can be a big problem down the road. Question number 4 this week, is a multi-member LLC different than a single-member LLC? The answer is obviously yes, because you have more than one person owning the LLC. But the question is, how much more complex is it going to be? And the answer is it doesn't necessarily have to be that much more complex, but you're going to have a different type of operating agreement because it has to spell out the responsibilities between you and your partner. On the tax side of things, a single-member LLC can easily elect for an S-Corp election, which is a tax election. However, if you have a multi-member LLC, you can normally still do an S-Corp election, but you want to work with your accountant to make sure that S-Corp election is the right choice for you and your business partners. So there is a difference. The paperwork is generally the same, but we just have more provisions. And that leads into question number 5 this week from the same client. What are membership interest transfer restrictions in your LLC operating agreement? So this comes up when you have your operating agreement that lays out all the different responsibilities, who owns what, and what the LLC is doing. We get down to membership interests. And the membership interests are who owns what in the company. Many of my clients want to have a restriction on the membership interest for when there's a transfer. So the restriction, for example, is you can't transfer that membership interest without everyone agreeing. So if you have two partners and one of them says, I'm done with the business, I'm just going to give my interest to my wife, or I'm going to give it to my brother, we want the other partner, the other member, to have the ability to say, hold on, I have the right to approve it or not approve it, and also the right, frankly, to purchase that interest. So if one of the two members is just done, or let's say we have 10 members, and one of the 10 just wants to be done with it, the other 9 could pool together and buy the 10th person's interest, and then the nine people can work in the business going forward, or they can find a proper buyer for number 10's interest and then take care of that transaction. But we want to have restrictions on how the membership interest can be transferred, because we want to make sure we can control who it goes to. The common scenario I see where things get really ugly is if one of the members goes through a divorce. And as part of that divorce, their membership interest becomes divided. And now, let's say you had a member who owned 20%, and the divorce court found that we're splitting that equally. Well, now you have 10% owned by the member and 10% owned by the member's ex-spouse. And you can probably guess that that ex-spouse is not somebody you want to own the company with. They'll show up at the meetings. They will make life as uncomfortable as they can for the rest of the members. Why? Just to get back at their ex-spouse. It doesn't happen in every situation, but in a lot of situations, that can be really painful to try to deal with, and is something you can easily avoid with the proper provisions in your LLC agreement. So those are 5 questions that came up this week as we started November of 2022. If you have questions for future episodes, there'll be a link in the description where you can view past episodes and also submit questions for future episodes. You can figure out, maybe there's a question we answered a couple weeks ago and you want to hop back in and then see what else we've talked about. So I hope everyone has a wonderful weekend, and I look forward to talking to you again next Friday.